The Sherman Act of 1890. The Sherman Act of 1890 is an antitrust law created to address centralized power in some classical commodities markets in America. Antitrust doctrine was developed in response to specific concerns about centralized power, especially Standard Oil Corporation's power to set oil prices. Standard Oil's centralized control of virtually all of America's oil production and distribution was concentrated in the hands of its chair, John D. Rockefeller. Now, Standard Oil was not one firm acting alone, but acting in concert via what is called a trust amid various corporations. You see, in 1882, state laws prohibited corporations from getting too large, and as an end run around these laws, Standard Oil established ostensibly different companies in different states, then caused those companies to engage in contractual agreements such that they would make decisions in tandem and act like one big firm. The trustees of these companies, including Standard Oil of New Jersey, and eventually some 40 corporations in all, signed what they called a trust agreement. It was called a trust agreement because it required the trustees to act and vote in tandem. And here's where we get the term antitrust. The federal government responded to this with the Sherman Antitrust Act of 1890, which made the Standard Oil Trust Agreement illegal. This landmark statute was called an Antitrust Act because it specifically prohibits agreements such as the trust agreement that Standard Oil Corporation signed. Such conduct is illegal under Section 1 of the Sherman Antitrust of 1890, which states as follows: every contract, combination in the form of trust or otherwise, or conspiracy in restraint of trade or commerce among the several states or with foreign nations is hereby declared to be illegal. Today, this language of a trust might remind contemporary people of a trust fund, but historically the concept of trust in the context of antitrust specifically referred to the kind of agreement that Standard Oil used to make a megacorporation whose many units operated in lockstep so they could monopolize the market on oil. By the way, this late 19th century attempt to break up Standard Oil did not really work so well. The modern oil industry is still highly concentrated with just a few large firms, and this structure can be traced back to the original Standard Oil Trust Agreement. There's also a famous contemporary, as in 1904, political cartoon. It depicts Standard Oil at that time, 14 years after the Antitrust Act, as an octopus. And this large central body is capturing various peoples and institutions through its many tentacles, illuminating contemporary concerns about this company's centralized power. The second key provision of the Sherman Act of 1890 criminalizes monopolization. As it is written, Section 2 of the Sherman Antitrust Act seems to overlap with Section 1, although today most authorities understand these two sections to deal with two different kinds of conduct. Here is the language where Section 2 criminalizes monopolization. Quote, every person who shall monopolize, or attempt to monopolize, or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a misdemeanor. It's a criminal statute. Now, Section 2 is typically understood to regard unilateral conduct, which would regard exclusionary or predatory behavior. To be clear, Section 2 of the Sherman Act of 1890 prohibits certain wrongful, single-firm, unilateral conduct. Section 2 is distinguishable from Section 1 of the Sherman Act. Section 1 prohibits concerted action, meaning combinations, conspiracies, and other multilateral conduct involving several firms. Several firms, Section 1. One firm, Section 2. The Sherman Act of 1890, the first federal antitrust statute in the United States, was not especially clear. It's quite short, somewhat vague, and seems to relate to specific issues going on with the Standard Oil Trust Agreement. Courts generally found it hard to apply the Sherman Antitrust Act to other cases. First off, it was applicable only to interstate commerce because of the Constitution's Interstate Commerce Clause. And almost a quarter century of suffering with these problems later, Congress attempted to restore antitrust authority by enforcing and enacting the Clayton Act of 1914. you.